Good morning, everybody. Welcome to our 41st episode of Cannabis Live from the Cannabis Legal Group. I'm Craig Aronoff.
I'm Travis Copenhaver.
And we welcome you to our show today. We're going to be talking about a number of different topics and items that are relevant to the cannabis industry here in Michigan, and in particular, the start of our new medical marijuana facilities licensing. Had a big day yesterday that we're going to give an update on. We're also going to talk about a few items that we're seeing from clients, in particular some real estate challenges, and just kind of answer any questions. And we encourage you to like us, share us, engage with us. We'd be happy to answer those questions throughout the show, or if we don't get to it during the show, we'll certainly get to it afterwards. So please share us with your friends, and we'll look forward to bringing it to you. So I mentioned that there's something that happened yesterday. We had a bummer board meeting. Our Bureau of Medical Marijuana Regulation met, and our licensing board got together. And what happened?
Yeah, so the board yesterday reviewed its first two applications. One was, I think they were both for secure transporters. And we learned a lot about what this process is going to look like. So the first application was for a secure transporter. The second, I don't remember what exactly it was for. But the main takeaway is disclosure and honesty. In the first issue, there was a conviction that the state found was about 20 years old that failed to make it into the application. And the board had a real issue with that. Apparently, this applicant, for whatever reason, omitted that issue on its application and its supplemental application. Laura informed them that they had found it, and then gave them an opportunity to remedy that. And apparently it came out that, I don't know how, it was kind of characterized as a bad thing the way the board talked about it, but more or less the gist of it was the applicant said, I didn't think you would find that, which is not something some of the board members wanted to hear. Yeah. Then the other issue was...
Well, before we get to that, let's just address that point real quick.
Sure.
It is something that's come up in a number of occasions, and in fact we work on some matters where the criminal activity, whatever happened, is way in the past, say 20 years in the past. And there's a matter, I just filed one just yesterday on that. The court records, the microfiche, if it's even there, we couldn't even find the case number. Like the name isn't anywhere, and it was a 7411 expungement. And, naturally from that point forward, the client had always thought, well, it's gone. It's not on my record, because that's how it was represented at the time of the plea. And what we know is that this FBI background check is finding all of that. Mm-hmm. And so I think the important takeaway from this is just because you assume that maybe it's not on your record, the fact it was there at all is what needs to be disclosed.
Right. And it was never an issue that this incident had occurred in this applicant's life. The state, and several board members mentioned it, that wasn't the problem. The problem was it was not included in the application. So it's all about being honest and disclosing everything you can. It's better to give them too much than not enough.
And what we did in the instance that I'm mentioning a moment ago is, and this is calling it, Laura and asking point blank, well, what happens if we have this situation? And what we were advised is to do, after the criminal history disclosure, disclose what we do know, which was generally the time of year it happened, and provided that, and then we put see attached letter. Mm-hmm. And my client wrote a nice letter that effectively outlined, listen, I know what happened. We went into the court. I contacted my lawyer. Nobody has any record of it anymore. So here's our best understanding and what happened. Okay. And that's what they want to see, is transparency. So again, the takeaway of that first, I guess what the outcome was is they ended up voting to table it.
Yep. So both actually got tabled. The other one had a similar issue where there was a criminal situation that wasn't included in the application. In this case, the incident was a little more recent, but it was 7411, so the applicant was under the impression it didn't need to be disclosed. The Attorney General did, confirm to the board that it's something that needed to be disclosed. Yep. And if you read that section, you could be pardoned by President Trump, and you'd still need to disclose that the incident occurred. Yeah. So in your records, when you're filing these applications, make sure that you're putting everything down. They're going to find it anyway. And if you have a situation where you just honestly can't track down that information because it was old, explain that to the state, as to the best of your ability, and work with them. Don't just assume they don't need to know it, because we know very clearly now that, yes, they do.
Yeah, absolutely. And And a quick question that we got, and I guess it's kind of topical to answer right now, is does 7411 possession charge bar someone from approval? And I think that the best answer we can give right now today is, this board is making its first decisions. The first ever 2 applicants it ever looked at as an operating board, other than when our next meeting will be, was literally yesterday, and they ended up tabling the 2. So I don't have necessarily a track record specifically to say, well, this is how the board acted under a specific set of circumstances. Next year we'll have precedent. We'll have that.
Right.
This year we got to give our understanding of it, and I think it's clear as the further back that 7411 charge was in time, the better off it is for purposes of getting away from it. But I think the more recent it is and the other extenuating facts could impact that board's decision.
Right.
And so we don't have a specific certain answer, but I think we have ways that we can maybe present the best cases to show why they likely will approve it anyway, like maybe yesterday's if it was disclosed properly, or maybe what we'll see in the future where.
And I will say this: some board members were willing to approve this application despite there being a 7411 on it. However, since the matter was tabled, they never ultimately gave us an answer to that question.
And one problem we had was we did have only 4 board members yesterday, so it resulted in, I think, a 2-2 tie vote on one application, and then they effectively
3-1 to table the other.
3-1 to table it, but it may have been because it was going to be 3-1 to deny it altogether.
Correct.
And so, it was a choice to move it that way. So I'm sorry we can't give a more direct response, but understand that we're not viewing it as a reason that you shouldn't be licensed. And we're encouraging people to allow us to review those stories, again, figure out timelines, and then try to build the case that since that event happened, what we've done in our lives to improve it to the point where we should be deemed a good citizen irrespective of that bad mistake.
Right. From what I saw, I'm encouraged that as long as you've disclosed it and explain it, you have a better shot, but it is hard to say, at the end of the day, if that's going to be enough to disqualify you.
Yeah, and so another big thing that came out was we've seen in the news and we've been hearing a lot about it, but we finally got some better indication from the board about these cease and desist letters.
Right.
Why don't we talk generally about that, and then maybe we can get to David's question.
Sure, of course. So I think everyone's probably aware that the state's been going around issuing cease and desist letters to marijuana businesses throughout the state. They explain what those are and how they're doing it and why. So, we now have the Medical Marijuana Facilities Licensing Act and licensed conduct under that act. So if you're out there operating a marijuana business and it's the type of conduct that would require one of these licenses, and you haven't either gotten an application in to temporarily operate, or you've not filed an application, or you're in a municipality that doesn't allow that conduct, the state of Michigan is going to start issuing these letters to you and requesting that you shut down. They've done about 200, they indicated yesterday, and they'll continue to do so moving forward. It's important to remember, though, that conduct that falls under the Medical Marijuana Facilities Licensing Act is not conduct that is necessarily the 2008 Medical Marijuana Act. So if you're a patient or a caregiver and you're doing what the 2008 law says you can do, not what you hope the 2008 law lets you do, but what you can do under 2008, you're not going to be the type of operation that's going to be in this instance. But if you're running one of those more gray market, pre-MMFLA type businesses and you're not taking the steps you were supposed to get into the license system, which they've been, they told you needed to file an application before February 15th and get your municipality's approval. There was an opportunity there with several months to have an opportunity to shift into that. So the businesses that were either unable to shift in or unwilling to shift in are the ones that are going to be the target of this initial round of letters.
Yeah, and I think another thing to dovetail into that too is even if you have a temporary attestation and you are effectively trying to be a future licensee, you're still acting within the scope of the MMMA. Mm-hmm. And so whether you're a retail center or a grower or a processor acting under the MMMA, your limits all apply, your patient-to-caregiver ratios all apply. And I think that these cease and desist letters are not only broad enough to say all those that didn't have the attestations or the proper documentation filed with the state by February 15th, but also those that may have filed them but are operating outside the scope of the MMMA and are potentially looking to start their 500 plant grow, for instance, rather than just a regular caregiver grow.
Right.
And so we got to find that little line in the sand that says until you're a licensee, you're not a licensee. You can't act like one just because the local approval said it.
We are in a transition period, and it's important to be careful during that transition period because technically you don't have a license yet. So
right.
until you get that license, the protection for that conduct, which would be illegal otherwise, is in question.
Yeah.
And
I'm sorry.
Oh, please,
I was just going to say, we know in Detroit this past weekend there was one of the operating attested to dispensaries, put themselves potentially in peril to get a license by maybe being too overt with trying to say we're already able to do this. Mm-hmm. You're not able to do it until you have your license, and until then, all you are is operating in that gray market, and it's time to be as careful as possible.
Right, especially if you have long-term goals of being a licensed entity. Yeah. The last thing you want to do right now is shoot yourself in the foot and do something you're not supposed to.
No doubt. I mean, it's just a matter of months. Why kill the time for years of success?
Well, we hope it's a matter of months. That dovetails into your question here. So David asked, why do you think there were only 2 applications that were reviewed yesterday?
I was just going to say, my understanding is that they didn't receive the other. There were supposed to be 5. They didn't receive the packets early enough in time to have them reviewed, so they can be prepared for yesterday's meeting. Right. And so they were only able to get to the 2 they were prepared for.
I think we are seeing some growing pains for a new board, a new program, a new situation. They're still trying to figure things out on their end. So
I mean, the Robert's rules of conduct were suspect too. So I think that that is something that is going to have to be resolved, and we'll see that maturity. Again, a lot of this is growing pains, as Travis said. So, as far as attestation for caregiving, I guess the question is if you're a caregiver, you never needed to stop doing what you're doing. There's no requirement that you do that. What you can't do is push the bounds of the MMMA. Mm-hmm. I think maybe selling overages and whatnot is going to be an area we're going to see some attention to. Right. Because that was never fully embraced by the state, and they always viewed that activity as not necessarily legal. So you like that roundabout way we say, we're not encouraging that.
Sure. So we did get some other insight from Laura yesterday as well. Primarily, they gave us an update on the number of applications they received up until this point. So they indicated that there are 411 applications in step 1, which would be your pre-qualification. And then, some of those, they're not sure yet what types of license they're going for, but specifically for the different facilities, they know for growers, they have 9 applications for Class A, 2 for Class B, 46 for Class C. For processors, they have 21 applications in. For provisioning centers, there's 47 applications in. For secure transporters, there's 2 applications in, and for safety compliance facilities, there's 4. So we're still in the early stages, but there are now at least applications for all 5 license types. So in theory, if one of each gets through, we have a program. It's just very, very small at the moment.
And we're going to need either more time with the board. I mean, even yesterday's meeting, however long it took, it was still only to get through 2. And so we know that by June 15th, from what they said, I think the other numbers is that they had, 215, I think, somewhere around there, 211 attestations, so temporary operators, who all have to have approval by June 15th in order to maintain operation in the absence of a rule change. And so to get that, we need the governor to sign off, because this comes in the signed emergency rules. So it can't be, I believe, an advisory bulletin that changes it. And so we just need to look out for those type of things, and hopefully the board will pick up its pace. Hopefully Laura can do its reviews and background checks and provide them that due diligence packet in advance. I know Chairman Johnson would like to have seen them more time in advance. But, I think it's just time for them to get to work and get people caught up, because we're all leaning on them now, and they should not be our obstacle.
Yep. So one more stat, and then there was another big item of news from yesterday morning. So the last stat is the state is aware of about 72 municipalities that are accepting applications. There might be more, and there just aren't applicants, going to the state portion of this process yet, which is pretty much in line with the number of municipalities we're aware of. We have a few that still have drafts that are in their final stages that we basically consider finished. It's more just they're cleaning things up and changing things before applications are being accepted. So
what's incredible is we're not even at 10% of the total municipalities in the state of Michigan. So keep that in mind as the course of this year, as your local municipality is seeing these, dozens of municipalities bring this online and seeing money flow to them. All the good, bad, and ugly, no matter what, we still need more townships, so we're constantly still working on the municipal ground game, and that actually, we got one more update from the board, and then we'll get into what the original topic for today was, which was challenges in real estate.
So finally, and there is an advisory bulletin that came out this morning to accompany this, is we finally have an idea of what the regulatory assessment fee is going to be. So if you recall, excuse me, if you recall, there are 3 application fees an applicant's going to go through. There's the local municipal application fee that's going to be about $5,000 or less. There's the state license application fee to submit your license, that's $6,000. And the final one is your regulatory assessment fee. Now the reason no one knew what that number was going to be is because it's based on the number of licenses submitted in a fiscal year. The more licenses there are, the less everyone has to pay overall. The state early on in around November told us that fee could be anywhere between $9,000 and $57,000 per license. I think the state, and this shouldn't be too much of a surprise to anyone, got less licenses than they expected. So unfortunately, that fee is closer to the higher numbers. So they have set the regulatory assessment fee for this first year at $48,000. Unless you are one of 2 types of licenses. Class A grows, that's the 500 plant count, has been by statute not barred at being ever more than $10,000. So the regulatory assessment fee for a Class A grower, $10,000. The other license type they decided is not going to have a fee at all is the safety compliance facility. That would be your testing lab. So if you're a Class B, a Class C, a processor, a provisioning center, or a secure transporter, your regulatory assessment fee will be $48,000. And that's the final step of the application process.
And that fee is actually only quoted through September 30th. So let's keep in mind that Michigan's fiscal year is October 1 to September 30. And so all of our budgeting and all of our numbers for these fees and everything that's being paid. Now, once it's paid, you get a 12-month license. But after September 30th, so come October 1st, when there could be hordes of newer licensees coming online, because given the pace that we're going, there's only going to be a handful approved by the time we get to that point, if any at all. I would expect that come after that point, there's going to be a lot more. And hopefully I'm joking and that there is a lot more before that, but given the pace of things, maybe not. But all jokes aside, the reality is that once we see those new numbers, we're going to probably see this assessment hopefully drop a little bit and absorb those new numbers. And so this is year 1. It could be year 2 also. We don't know yet. But hopefully we're going to see that precipitously fall. And so people that are going for multiple licenses and all of that aren't overly burdened by a regulatory fee.
But it is important to keep in mind, if let's say you're going to vertically integrate and have a grower license, processor license, and a provisioning center license. Well, unless you're a Class A, that's $48,000 for your grow license, $48,000 for your processor license, $48,000 for your provisioning center license.
Yeah, $144,000. So it's pretty substantial. So have that ready in capital because this has to be paid upon licensing.
Yep.
All right. So I guess we've kind of covered everything from the bummer. I think that we'll see more information come out for advisory bulletins. We'll do our best at Cannabis Legal Group. You can follow us on our webpage as well as on Facebook. With respect to today's topic, and it might be a little bit wonky, but we were always talking about real estate. So last several blogs we've done, a couple of other posts we've done recently were really about municipal level work. And once you find real estate, what do you do with it? How do you get through the municipality? Well, one of the challenges that we're constantly seeing is in the area of actually closing the transaction and buying the real estate, because we know that there is federal issues related to title companies and mortgage companies and real estate. And so why don't we frame it a little bit more, and then we can talk about what title insurance is and whatnot.
So Craig, I want to buy a piece of property to use for my cannabis business. You're going to sell it to me? What do we do? What happens?
Well, what happens is of course, we have a contract, and then we have to decide, all right, when are we going to complete the contract? In order to do that, I got to pay money as a buyer into somebody so that they can transmit that to you, and in turn, you give me a deed to your property. And so if we did it on a proper piece of paper, and we sat and I gave you a check personally and you gave me a deed, that could work.
Okay.
Now what happens though is hopefully my deed is valid, so that's an issue, and hopefully my check is valid.
Right.
Or your check is valid.
So I would be hesitant to do that, because just because you claim to be the owner of this property and you claim that your money's good, I'm kind of trusting that check's going to clear and that this deed's going to be something I can defend if some other person comes along claiming that they actually have a legal interest.
Right, because what happens in Michigan is, and this isn't true every state, but Michigan is pretty general in how close it is to other states. is that, first in time, so the person who is on the title, when you get that deed, you record it, and it goes to the county, and the county puts it into its registry at the Register of Deeds. And every itemized document that happens on your property, on the title of your property, is registered at that Register of Deeds, and Michigan follows it in a timeline. And so everything that happens before you is something you're subject to, and things that happen after you are things that happened after the fact and aren't really going to, curtail your interest. And so what we need to do is first have that checked, because it requires somebody to literally go to the county and pull out all the records. And if there's, say, a deed there, were the people the right people? So who's the owner at the time?
Right.
And then when they sell it, did that person receive it properly? Were all the name signatures correct? Okay. And then if there's a bank loan and they had a mortgage on the property, was there a discharge of that mortgage? Was it paid off? And so the title company is the entity that would be hired to go and do that review. And in the past, they would literally send a person to the county to sit down and do the abstracts and go through all of that title. In the present, with all the online databases, it can be done very efficiently through a lot of computer digital work, but nonetheless, it still takes the same review.
Okay.
You got to literally look at every document on the record and then document what's there.
So then they decide, okay, yes, what this seller says they have is in fact true.
Okay.
Right? But beyond that, though, how do I trust the title company?
Well, this is where they have what's known as E&O coverage, so errors and omissions coverage. They're a licensed entity in the state of Michigan, so they're professionals, and they warrant their work. And so that's why you're hiring them to do this. So the first thing they do is a title search and show you all the different things that are on your property. And then what they'll do is they'll say, if you want us to help close the deal and insure this deal, what we'll do is a commitment. And the commitment actually says, this is exactly what we will insure. And on that commitment, it'll talk about the things that you need to get rid of. Like the first thing is you need to have a deed from the sellers to the buyer. That's one of the items that would be insured. The other things would be is that a mortgage might be there, so you get a discharge recorded saying that that mortgage was in fact paid off. Okay. And so those are other items. Maybe there's a water bill that has to get paid, because water bills do run with the land and they are responsibilities of the landowners. And so that's another item that would have to be taken care of, as well as property taxes. And so the title company will kind of lay out in a report form all the different things that you need to do in order to be receiving a proper deed from me as the seller. Okay. Okay. And so what we do is that title company is hired, and part of that is they're given an insurance policy to you as the buyer from me as the seller that says, I promise you that all these things in this commitment are taken care of and you don't ever have to worry about it.
Okay. So that protects me, the person who wants to purchase this land.
Right.
Okay.
It does protect you, but keep in mind it protects me as a seller also, because if I'm giving a warranty deed, I am guaranteeing or warrantying that my title is clear for you, and if a defect happens, then I'm responsible to cure it. Okay. So you would sue me, but instead we would use your insurance that you just got from me to pay for it. Okay.
So as the person who wants to run a cannabis business buying this land, in order to buy it from you, you feel better that I have a title insurance company, because if I do have to sue you over something, it's really them that's bearing the brunt of that, not you.
Yeah, and the other thing that the title agency does is they act as the escrow agent. So what will happen is you'll put your money at the title company. Okay. The title company would then pay me and take out of that any cost to close it. If there's a mortgage that had to get paid off, that'll be used out of those funds. If there's a realtor who has to be paid their commissions, that's paid out of it. If there's property taxes, generally the property taxes get reconciled at the closing, so that if I prepaid them, I get reimbursed the amount that I already prepaid. And so that's something that the title agency manages the money on everybody's behalf as well, and then issues checks and distribution, and then you get a deed that they record, so they take it and handle that. And so you're paying them to manage the money and manage the documents in order to walk out of there with the keys to my property, and I walk away with all the money I expected from selling it to you and not worrying about you ever coming back to me and saying something happened on the property that I am responsible for.
Well, that all sounds great. What's the problem?
Well, the problem is that in the cannabis industry, these title insurance companies are national title underwriter providers. And so First American and Fidelity, for instance, which are the two largest insurers of title, both have issued basically restrictions to their agencies saying you cannot use our insurance to underwrite for any cannabis-related properties.
Okay.
And so in turn, what the title agency says is we can't even act as an escrow agent because if we can't underwrite it and provide the coverage and we can't do the full scope of work we're supposed to be doing, and our E&O coverage won't cover us to manage your not permitted property under their guidelines. And so for them to maintain that ability to write the insurance, they have to follow rules. So that takes us full circle to say, well, I'm buying a piece of real estate. Do I even have to disclose it, right? So why don't we talk a little bit about what concern you would have?
So I want to buy this piece of property. I assume you as the seller wouldn't want to go through that selling process without working with a title company. I don't know what I'm going to use it for, but I really know what
a little bit about the use. And then separately, so we have to be careful there. You cannot not disclose something you're asked. Right. Let's be very clear. It's mortgage fraud and title fraud if you go ahead and actually say something that isn't accurate when you knew it to be inaccurate. Okay, so
don't commit fraud.
Don't commit fraud. Now, it doesn't mean that we can't have a real estate investment and we can maybe use our own cash for it, and then maybe the title company's not really caring what we're using it for because that's not a question they'll ask. Maybe our buyer shouldn't have a business saying like, Ganja Company of Michigan or whatever it is. Right. That's so crystal clear it's a cannabis use. Because in a lot of our circumstances, what we're doing is the owner of the property is not necessarily our licensee.
Right.
Right. And
you can act as a landlord or maybe even invest that property to do something else.
And maybe they're not even part of the licensee. Maybe they just purchased the property and the entity purchased it in order to be a landlord. Later on a licensee comes on. But the key here is that if the title company is aware of it, they're not going to allow the closing.
Right. And even if the title company becomes aware of it later, now what's going to happen? Now they know what I am using it for, a cannabis company. Isn't that going to cause some problems?
Well, what it'll likely do is cause them to rescind the policy itself. And really what that goes to is the protection between me as the seller and you as the buyer. But there's generally not much other recourse. Now, if something does happen and they have to file a claim for that insurance, that's where they'll probably deny the claim based upon its use at that time. Now, there's an argument to be made, of course, that the use had nothing to do with the defect. So maybe there's an argument around that, but that's a problem for a day we don't want to have.
But a savvy seller is not going to want to necessarily sign up for this mess. So the challenge that we see is when you want to purchase property and you want to do it for cannabis, it's going to make it difficult to convince a seller to work with you and go through a traditional process of going through title insurance and things like that.
It is, and again, we just have to work our way through that. We don't ever want to be not transparent where we need to be transparent, but as between a buyer and a seller, it's not really relevant to the seller what the buyer intends to use. Mm-hmm. And so, again, there's no requirement there that you have to say exactly how and why you want to use it to your seller. And so if that's an issue of the seller, which we've seen in some communities where they're not interested in leasing or selling to a cannabis industry, and they ask that question. And, again, transparency and honesty, but this isn't an area where I think it would have, between the buyer and sellers, as relevant as between a title company and a buyer.
Right.
And so to that end, we just need to make sure that we know exactly what we're buying. We can do those title searches. We can do those commitments. We can work with escrow agencies, maybe that aren't title agencies, law firms and whatnot. But we just have to make sure the bells and whistles are set up so that everybody knows that the money being transferred is good and that the deeds being received are good.
Right. So it gets complicated, I guess, is the summary. And understanding that there's some challenges there might make it difficult to move quickly when you're trying to lock a property up to put in a competitive application when, there's only going to maybe be 3 in a municipality. So being proactive and anticipating that and being in a position to manipulate the materials you need to and get them, I's dotted, T's crossed, everything filed is going to be important. Because as you find when you get into these application projects, when you're in different municipalities, deadlines come quick. All of a sudden you have a week to make everything happen and you need all those pieces to fall in place.
That's absolutely right. And certainly we want to be sure that, there's good counsel through those transactions. And that's a very important component of it. So right from the onset, working with whoever your representative is. Certainly us at the Cannabis Legal Group, we spend a lot of time working with our clients on not only assisting them locate properties through other professionals, realtors and whatnot, but also initially on the formation of the entities as to be purchasing and the strategy for closing and going through all the different things necessary to have that successful closing.
Right.
And so, well, we just want to remind everybody to continue to pay attention, do your due diligence, and don't jump too fast on a property that might not necessarily qualify. And at the same time, act and be ready to move when you got that one at the end of the hook and you got to close it and bite it quickly.
Definitely.
Yeah, because we've seen some people lose property quickly too, and it's an amazing market right now. It's very fluid.
And a lot of sellers know what they have and know why you want it, and aren't necessarily going to be naive about why all these businesses are suddenly interested in buying their piece of industrial or agricultural property. So.
Yeah, well, we covered a lot today. I know there was a lot with respect to the Bureau board meeting and all the update that happened there. Certainly, if you have questions after the fact, feel free to reach out. We're doing our best to stay up to date and current with everything going on. Certainly, with respect to real estate, we've seen those challenges. If anyone has any stories to share or anyone want to work through any problems, certainly reach out to us. Those are things that we'd like to work with you on. But in the meantime, we'll be looking to continue to get our applications filed, continue to get our clients' projects moved forward, get more municipal approvals, more municipalities on board. We're both going to different townships next week.
That's right.
Just a big part of what we do.
So see us out there in your evenings, in your town halls,
That's right.
and city council meetings. Feel free to say hi.
That's right, and we look forward to seeing you out on the road there. So until next week, we're bringing on new topics within the MMFLA and all the things happening here in Michigan's cannabis market. I'm Craig Aronoff.
Travis Copenhaver.
We'll see you then. Thank
See
you.
you guys.